Yes.
Let's say if in a case that you were presiding over, the person had like failed the field sobriety test. Those exams, like the balance, like walking in a straight line or holding your foot up. Personally, I have horrible balance. So if, let's say, I was pulled over and I failed that, and let's say I was taken to court, what would be your reasoning? Would that be more likely to say that yes, I was impaired, or what?
You mean, would I find you guilty just because you have bad balance? Well, if you look at it, they do a number of different tests. They'll do this. They'll do finger to nose. They'll do walking a straight line, heel to toe. But they give you a variety of tests so that if you say, I just have terrible balance, then you can rely on the other tests that were given. And you can rely on the totality of the circumstances, all the information. How were you driving? How did you speak? Were your words slurred when you were talking to the officer? Did the other things you do make sense? Were they logical or coherent? And if they're arresting you, they'll give you a chance to take a breathalyzer. And if you hadn't been drinking and you have bad balance, take the breath test. So there's a lot of circumstances. It's not just any one test. Yes?
As a judge, do you think it would be better to be a prosecution attorney or a defense attorney?
Well, I have a bias because I started out in the public defender's office. And so from my perspective, I agreed with what Michelle Suskauer said. They're both very important and very critical jobs, and both of them need to think independently and critically. One of the reasons that I went to law school, even though I didn't know at the time that I wanted to be an attorney, was I thought it was a great education because it taught you how to think and analyze critically. And it does. And whether you're a prosecutor or a defense attorney, you have to do those things. Now, as a prosecutor, when you're trying to prove a case, you look at the statutes, and any crime has specific elements. DUI, they were drinking, they were impaired, they're impaired to the extent that their actual physical control was negatively affected. So you go through your case and you go through your facts and you say, okay, I have to prove A, B, C to make my case. And that's fine. For the defense, there are as many different defenses to a crime as there are theories about how the crime was committed. So when you're a defense attorney, you're not just proving elements of a crime, you're trying to prove that the crime wasn't committed. And it may not just be putting on evidence of A, B, C. You have to be persuasive to a jury that your theory of defense is important and it makes sense and it applies to the facts of the case. You have to convince a jury who's looking at the facts that this is the way you should find the facts. Because the jury decides the questions of fact, the judge decides the questions of law. So you want to be able to convince that jury that your theory of how this all happened is what they should agree with, and not whatever the theory of the prosecution is. So from my perspective, defense needs to be a bit more creative, but I don't say that to take anything away from the prosecution because they have a very tough job as well. Yes, sir.
Going back to the case that we just saw, it mentioned expectation of privacy as far as being in the back seat of the police car. And it stated that there was really no expectation. So does that mean that that could still be used in court even though there was no Miranda rights?
Yes, because it wasn't a statement given in response to a questioning of a law enforcement officer. It was something that was just blurted out voluntarily. And sometimes, if there are multiple suspects in a crime and they get placed in the back of the same patrol vehicle, I've seen cases where they start talking to each other about what their excuse should be or what their defense should be or, what are we going to tell the police? And they don't realize all that can come in. So they hang themselves, so to speak, sometimes. Yes, sir.
Your Honor, are there any standards you uphold as a judge that are not necessarily prescribed in legal guidelines?
Judges have guidelines for professionalism. For years, we tried to encourage attorney professionalism. And it used to be that attorneys were considered problem solvers. They were respected in their communities, and a lot of them still are. But sometimes today, people look at attorneys as problem creators. And it's unfortunate that some attorneys have that reputation or that stigma. So the bar, the legal organization that controls the practice of law, tries to institute and enforce guidelines for professionalism for attorneys to make sure that they behave professionally, that they behave courteously, not only to the court, but to other attorneys, to all the parties they interact with. And that went on for a long time, and then finally we realized, judges should have those guidelines for professionalism also. And they're slightly different, but we have guidelines for professionalism that encourage judges to behave properly, not to be rude, even if it is that attorney who's unprepared, not to be discourteous and blast them or embarrass them in front of other people in court, but to address the behavior in a respectful way. And so all judges aspire to follow those guidelines. Yes, ma'am.
I find that cases are stay in the legal system for months.
Or years.
Yeah. Why do they keep rescheduling? Why don't they ever just solve it in one time? Why do they keep rescheduling and send it through the court system for so long?
Well, the most glaring example of that is capital cases, death penalty cases. And when you're talking about a person's life, you want to make sure you've done it right. And sadly, those can drag on for years, and then the appeals can take years more because you want to make sure that when that case goes to trial, the state and the defense have had every opportunity to fully prepare, to know what every witness is going to say, to know what the evidence is going to show, to be prepared to challenge legally those things that should or should not be admissible. And that takes a long time. And then on top of that, you've got prosecutors who may have a death penalty case who have 50 or 100 other cases that are going at the same time, and they have to balance all of that scheduling. Defense attorneys who may have as many or more cases, they're trying to balance. And so it's tough to get all of those things to come together when both sides are completely ready and the witnesses are all available and the court has trial time. It's not trying another murder case or something else. And so it drags on. And ideally, it would be nicer to be more timely. And part of that is a function of the number of judges that we have. And that's a function of the state budget. Because if we had more judges and more prosecutors and more defense attorneys, we could move more quickly. But that takes more money from the state. And you know how tough the state's budget is. Yes, ma'am.
What do you like most about your job?
What do I like most about my job? I feel like I get to make a positive difference in people's lives. I feel like I get to resolve disputes peacefully in a way that a lot of countries can't do. I feel like I get to listen to beautiful, intelligent arguments from both sides of a case, civil or criminal. And I feel like I get challenged every day. I feel like I learn something every day because as much as we do this, there's a tendency to think, well, I've heard this before, like the two-beer thing that you saw in the video. When I was a county court judge in the criminal division, I can't tell you how many times I heard what they would call the two-beer defense. Oh, I only had 2 beers, because it's the easiest thing for people to say, and they think, well, that doesn't sound too bad. But you have to remember that there are people that really only had 2 beers, and maybe their balance is bad, and maybe they're having a bad night, and maybe they're emotional because they had a fight with their boyfriend or their girlfriend, and that's affecting their behavior. So you learn something new every day, and it keeps you honest and it keeps you humble, because as much as you want to think, well, I've heard this before, every day life is full of surprises and you hear something new. I could think, when hearing one side of a case, well, I know how this is going to go. And then you hear the other side and you think, well, I never thought of that. That makes sense. And so it really keeps you balanced and it keeps you learning, which is a good thing. We're out of time, but I want you to do one thing before we leave. Everybody stand up. Put your hands at your sides. Look straight ahead. Lift one foot, I don't care which one, 6 feet out and count to 10.
1, 2, 3, 4, 5, 6, 7, 8, 9, 10.
Okay, who are we going to arrest in this group? Julie. Right here. Okay. All right, thank you very much for letting me come do this. I really enjoyed it. Thanks a lot. Thank you.